Good morning, everybody. Good afternoon, in fact. My name's Henry. I'm part of the team from the Chamber. I'm very proud to be joined by Martin Kingman from Pro Legal Group Limited today, who'll be doing a presentation for us. If you have any questions throughout the presentation, please do feel free to put those into the chat, and then we will do a short question and answer session as soon as Martin's finished with the presentation. So, without further ado, I'll pass you over to Martin Kingman. And Martin, ready when you are.
Hey, thanks, Henry. Thank you all for attending. I thought I'd start by just giving a bit of background as to who I am. So I'm the CEO of the Pro Legal Group. I'm a debt recovery and insolvency lawyer by trade, but I also run a suite of professional service companies, which includes a debt recovery business, a full service law firm, a compliance business, an IT business, and a contract terms and drafting business. So I've got a bit of background in this. I've been doing it, in fact, 23 years tomorrow. So I've got quite a lot of experience. And with T's and C's are really, really important, which we'll come on to. But from my point of view, it's all about prevention is better than cure. As a litigator, we're having to use T's and C's, and that means we need to really have robust documents to actually fight with if we're at that stage. So I much prefer being on the front foot and being preventative with this sort of stuff, which is why having these T's and C's is so important. Obviously, this is a massive topic. I could literally do probably a 2-day seminar on this. So it will be a whistle-stop tour. Do apologise for that. If you have any questions, as Henry said, please do put them in the chat. I'm going to talk for about 20 minutes or so, and then we'll have a 10-minute at the end Q&A session where you can chuck some curveballs at me, and I can see how well I can answer those. If they're not too nasty, I hope anyway. So right. So moving on. What I thought I'd do is I actually thought we'd actually look at sort of some contract law and some contractual stuff first, because this really underpins everything to do with T's and C's. So really good question. Why do we need T's and C's? Effectively, they give you a framework that everybody knows what page they're on, everybody knows what they're doing. It's a really important way to make sure that your house is in order. If that becomes a problem, that's not the time to get your house in order. The time to do it is at the beginning of the contract when everything's happy. And I see it so many times as a litigator that doesn't happen. People are so excited to win a new contract. They go off down the road and they're running through, and all of a sudden something goes a little bit bandy, goes a little bit wrong. And all of a sudden it's like, we've now got a problem. And at that point, it then becomes generally a difficult and expensive problem, which could have been avoided by having terms and conditions. The idea is to have a suite of documents that literally just protects you in your business so that you know what you're doing. So first, I want to look at actually how do we incorporate the terms into a contract. So a contract, agreement between two parties to be bound by certain terms. How do we get those terms into an agreement? This is the thing that most businesses don't do very well, if I'm totally honest. I won't ask for a show of hands and embarrass people, but a lot of people will actually put their T's and C's on the back of their invoices. And of course, the invoice is sent over at the time that the work is completed. Well, if the terms aren't in the party's mind when they form the contract, they're not valid. So if you're going to be bound by terms, you need to know what those terms are at the outset of the contract before you can be bound by them. So the T's and C's need to be sent over absolutely straight away, as soon as you can. So literally on the very first order, very first point of contact, as soon as they're talking about actually entering into a contract with you, make sure your T's and C's are sent across. Battle of the Forms. Now, the Battle of the Forms happens where one party sends you their terms, you send them their terms, your terms back, and the terms are different. And the courts have to try and decide in that situation, well, which terms apply, because both parties have sent terms, which one actually trumps the other. And the law on it basically says that it's the last one before the contract was signed. So whoever gets the last shot across the bow before the contract's actually entered into, it's their terms. Case of Manchester Council versus Gibson 1979, if you're interested in the actual law. There's quite a lot of case law on this because it's been quite an area of dispute for, well, nearly 50 years now. What we always recommend is actually, if you've got another party who is sending you their terms, go through them, have a meeting and actually decide which are the key terms, and then incorporate a document together that actually brings together the points that you both want to include, the important points. Very, very happy to take, to assist people on that if need be. But that's an important one to actually make sure you've got those. So what actually constitutes a contract? We talk about contracts all the time. Do people actually understand what forms a legally binding agreement? Well, you have to have a certain number of elements. You can have a thing called an invitation to treat. So with a contract, you get certain other elements, which I'm just going to put on the screen now. So you get offer, acceptance, and consideration. So an offer is an offer to be bound by certain terms. Acceptance is the unequivocal acceptance of that offer. And the consideration is what they call the price paid for the promise. Something has to move from one party to the other as a level of bargain. Now, the courts are not interested in whether or not it's actually a good bargain or a bad bargain, providing there's been some level of consideration that's good enough to be their contract. There has to be other things like an intention to form legal relations as well and things like that. Invitations to treat are quite interesting because they are not actually a contractual term. So an invitation to treat could be things like a shop window. You see a sign in the shop window that says TVs $5.99. Should say $5.99, and somebody's put a decimal point in, and all of a sudden it now says $5.99, and people rush in and say, "Oh, you're contractually bound," and you're not. The courts are quite clear on this. That is an invitation to treat, which is an invitation for you to make them an offer. With terms and conditions, what we always try and do is put you as the person whose terms they are in the driving seat, because in the normal contractual life, you make an offer, they accept the offer, and then you're bound. By making your initial offering an invitation to treat, you can then reverse this so that the person you're dealing with actually makes you an offer rather than making an acceptance. And then you can have the next stage, which is making the acceptance to actually decide that you want to be bound on those terms. Now, this is really useful, especially where there's a passage of time or things like that, or where something changes, or you may change your mind. You know, sometimes you get clients, you think, "Oh, actually, I've got a bad feeling about this. I don't want to go ahead with this." By changing that around, you can actually make yourself in a position of power where you go, "Okay, what we're going to do is actually at this point, I'm going to say, no, I don't want to accept the offer. We haven't got a contract and we're not going to proceed." It just gives you that information and that power. So, and I do apologize because today is really sort of whistle stop. You know, we're 7 minutes in already. And literally there's, you know, as I said, I could do 2 days on this at least. But that invitation to treat, offer, acceptance, consideration, what forms the actual contract really needs to be thought about in relation to your process. So let's carry on. What terms should we have included in our T's and C's? Every business is different. T's and C's should be bespoke to your business. Now, I don't know how many of you remember this. During the middle of COVID, the government awarded a transport contract for a boat company for about 53 million quid. Lucia's nodding her head. And when the papers actually looked at it, they'd actually nicked the T's and C's from a Chinese takeaway. So they've been awarded a £53 million government contract, and literally the T's and C's came from a Chinese takeaway and weren't at all fit for purpose. And funny enough, that caused a lot of consternation. So I'm never a great advocate of stealing terms from other people because, to be fair, they generally don't follow the process that you actually need. And it's like everything. The protection's only as good as the time you invest in it and actually making sure it does meet what you say you're going to do. So that's really important to be sort of on the ball with this. So this is the biggie for me. This is the one that I see businesses get wrong 3 or 4 times out of 10. They don't understand legal entities. They don't understand who they're actually entering into a contract with. There's lots of different legal entities, maybe a sole trader, could be a partnership, could be a limited company, could be an LLP, could be a charity, could be a trust. There's a whole range of different legal entities, and you have to be really clear and identify exactly who it is you're entering into that contract with, because if you get that wrong, then potentially the person you're dealing with isn't the person you've actually contracted with. And I hope most of you realise that then can cause you quite a lot of issues further down the line if you need to take the nuclear option and actually start to enforce. So I'm a great advocate at the start of a relationship to actually look at things like new starter forms and, you know, credit reference checking. It's a service that we offer as well in relation to that, where actually we will credit check clients for you to make sure that actually they are the people they say they are and they're the correct people behind it. Because again, it could be a costly mistake when that comes unstuck. So really identify what legal entity it is and who it is exactly you're dealing with. Payment terms. We're English. We don't like talking about money. It's really bad. We sort of shy away from it, and we sort of, the money's going to be, and then we think, oh, is that enough? Have we, you know, can't really say that out loud because that's a very big sum and all this. Like, it's what we do. You know, we're not like the Americans who are, you know, how bold and proud and we're going to go for it. Payment's so important. It's why we're doing this. We're in business to make money. It's so important, and so often I see that payment terms are actually missed. People don't actually put down in the agreement what they're going to do and what they're going to charge for it. And yet that's the whole purpose of having these agreements, is to actually be really transparent and clear. And it saves so much money and time and effort. And when you consider the nuclear option in litigation, it's not just the cost of litigation that you've got to worry about with that. It's also the time and effort and the human factors for you of actually all that engagement in the process that's basically chasing dead money and things like this. So prevention is so much better than cure. You also need to think about payment terms in terms of things like late payment. So if you're business to business, under the Late Payment of Commercial Debts Interest Act 1998, you can charge 8% above base rate on any outstanding invoices. There's also compensation that's allowed under that act, and you can also claim a fixed legal cost as well. So it's a nice way, it's a nice mechanism to have some beef to your terms, so that if people aren't paying you, you've actually got ways to make money to reimburse you for the time. None of you on here, I believe, are banks. So I looked at the attendee list earlier, and certainly there wasn't a bank in the list at the time. So why are you giving away free credit for indefinite periods of time? Nobody else gives away free money, so I don't see, the banks certainly don't do it. So I don't see why you should as a business. If people aren't going to pay you, then you should be using interest to make sure you're actually getting your money back. And you know, we can assist with that if we get down to that point in the time. Cancellation rights. How does somebody cancel the agreement with you? This is particularly important for consumer credit and consumer, when you're dealing with consumers, so individuals who are not in the course of business. The Consumer Rights Act 2015 lays out what used to be called the distant selling regulations, whereby where a contract was formed, there was a cooling off period. And basically, if you did work within that cooling off period and there wasn't a waiver exempting it, then the person had a right at the end of the 14 days period to say, actually, I don't want that work done. And anything you've done, you wouldn't be paid for, even if you completed it. I'm not a big fan of that legislation, I must admit, because I think it gives people avenues to run down and they can be quite disingenuous with it. But I understand the reason behind it is because of pressure sailing and things like that. So if you are doing stuff, particularly with consumers, make sure your T's and C's deal with that and put the cancellation in right. And also make sure you've got a waiver in place that if you do carry on work within the 14-day period, that actually what you are doing is you are getting that waived by the person before you start, so that you're not putting yourself at risk. A lot of this stuff is about managing and balancing off the risk. Termination. Literally yesterday, I was advising a client on a contract that literally didn't have a termination clause. And one party is trying to argue that that means the contract lasts forever, which the courts don't like at all. But it's a really simple one. You know, how is the contract going to come to an end? How can a party end the contract with you? I'm assuming most of the people here are in the course of business. So at some point you'll want to look at moving on. You want to have the right to actually cancel with that client, because it may be that something else comes along. You want to do something different. You might stop acting in that area. You might not do that anymore. And you think, well, okay, I need to now get out of this contract. So there should be a way for that contract to be formally ended. And that's sort of really important. Force majeure. This has become a hot potato in the last couple of years in particular. Basically what it means an event beyond the party's control. The big one that we've all been talking about the last couple of years, if you haven't been living under a rock, is obviously COVID. COVID made a massive amount of issues. And what we are seeing with T's and C's now is that pandemic and epidemic is now being specified as a force majeure element, whereas before sometimes it was and sometimes it wasn't. Certainly pandemic really wasn't. Epidemic sometimes was, things like bird flu, but now pandemic and epidemic, you'll see those in lots of T's and C's that give parties an ability to get out of the contract if they can't deliver it. you know, at the end of the day, you can't have it just lives in abeyance forevermore. So that's really, you know, really important to actually look at those sort of terms. Limitation of liabilities. We do a lot of work in the construction sector in particular, and they have a thing called LADs, liquidated damages. And effectively, with liquidated damages, you can find that actually you're getting striped for a lot more money than the actual contract value because of delays that are caused if they're caused by you. So you have to be really careful to make sure you really understand what liabilities you are accepting within a contract and kick back. You know, I say this to a lot of people. If you're not happy with that, don't do it. You know, you don't have to sign these things. And I know it's really, really important. People want to get on board and say, yes, you know, want to get going with this, can't want to earn this money. If it's going to cost you a lot more in the long run, it just isn't worth it. You've got to balance off that risk. But the clauses should be there to sort of looking at limiting your liability. And again, what liability you can't limit for things like death and personal injury, you can't limit those at law. That would be unlawful. But other things you can, where you can't, insure against it. Go and get a decent insurance policy to make sure that you've got protection. It's like people with landlords. You know, if you're a landlord and you've got a portfolio of properties, buy landlord insurance, because actually, if you have somebody who's defaulting and not paying you, it's a long process to get them out. And actually, landlord insurance will end up paying you the rent that they should have paid you. So you're protecting against it. Yeah, it's costing you money to do it, but actually, from that point of view, there's a lot of protection. So we're sort of looking at that. Jurisdiction. So I collect debt all over the world. We do a lot of international debt recoveries, USA, Singapore, Canada, Far East, Australia. And obviously there's lots of different jurisdictions. With T's and C's, if you specify the jurisdiction is always going to be England and Wales, then you know that you've got a home result if you got the off contract in the right way. And that's really important because it means you're going to bring a claim in the UK if we have to bring a claim at all. If, for example, you're dealing with, let's say, an American company, in each of the different states, there's different laws in the United States. So all of a sudden, then you're going to need to work out what the law is in that particular state before you can start taking action. Whereas if you've nominated it as being England and Wales and the laws of England and Wales, and the courts have exclusive jurisdiction within England and Wales, you're fighting a home game. You know, you've got a home fixture, not an away fixture. And that's going to be much more straightforward and much more simple for you. In terms of jurisdiction, the process, if you want to look at issuing claims, if it gets down to that stage, is generally you have to get permission from the court to issue out of the jurisdiction. You get the papers served over there. They get an extended period of time under CPR Part 6. And then you can then go ahead, ask for permission to enforce, to get a judgment, a CCJ. And at that point, then you can then get it registered in the foreign jurisdiction as a judgment of that state. So, for example, with the states, once you've gone through that process, and let's say we're going to do it in Washington, the point we then get the county court judgment, the CCJ, at that point, we can then send it to a local agent in Washington. They will register it with the courts in Washington as being a local jurisdiction claim effectively. So they will give it a validity in their jurisdiction, and then they can go ahead with enforcement in that jurisdiction. So it's much easier than running the whole process from Washington, especially if you're sitting over here in Kent, with the time difference and everything else. It makes it quite difficult. I'm going to go on to the Q&A now because I appreciate there's probably some burning questions, as I hope there is. Otherwise, we'll be ending very shortly. But effectively, thank you very much for sort of listening to that. And I do appreciate it's a whistle-stop tour. My details are on screen. If you want any further information, there's anything I can assist with, please do reach out. We're always happy to sort of assist. And no obligation conversations. So it's not just we've got a clock ticking, so don't worry about that. It's all about actually the service. Henry, have we got any questions?
Perfect. Currently, we're just waiting to see if anyone will put any questions in the chat. I've just put a message out. So if you do have any questions at all, feel free to put them in the chat. Equally, if you'd like to unmute and just ask straight away, we're more than happy for you to do so. But of course, thank you so much, Martin, for that presentation as well. I thought that was really informative. And I know, like you said, it's a bit of a whistle-stop tour and there's so much more to it. But I think that you covered off as much as possible in that short time frame. So it's very much well done. So does anyone have any questions at all?
I've got one, Henry.
Perfect. Hi, Lucia. Feel free to ask away.
Yeah, Martin, I'm wondering why so few companies actually enforce the 8% late payment rate? Because I see it time and time again that companies hate doing that, don't they?
I wish I had an answer to that. 75% don't do it. Is it that was the latest stats that I read? So 3/4 don't ever do it. If we go to the point of being asked to collect debt, we will do it as generally standard.
Yeah.
The thing to talk about with interest is obviously if you have a rate specified in your terms of business that isn't under late payment, then so if you have a different rate, then that contractual will trump any late payment. So some people have like 3% in their contracts. They then can't use late payment because they've got it in their contract. So I always recommend in your T's and C's, put late payment debts will apply. If you make that part as a contract, it becomes a contractual term, even though it's specified in an act, and that's the best of both worlds because you can still get the compensation as well. But I wish I could answer that question as to why so many people don't use it, because to me, it's very disappointing that actually people get away with it. I mean, there's a late payment code, and a lot of big businesses in particular. I mean, the Late Payment Commercial Debts Act was introduced 25 years ago now, in 2008, 1998, even 2000. So it's that old. It's even last century. And it's one of those where the government were a 3-line whip. You must pay this, everything on time. But even now, with government departments, we're still seeing stuff is slow and late, and councils are slow and late. It's just a really poisonous culture, because the problem is it's like ripples on a pond.
Mm-hmm.
You know, you now can't pay people. You now don't pay 3 people because you've not been paid. Those 3 people now don't pay 10 people. And all of a sudden it's, becomes a massive issue. It's a bit like when the big companies, look at Carillion, when Carillion went bust. The ramifications down the supply chain are massive. So I'm a real big advocate of using the legislation to actually make you money. On a lot of our debt recovery jobs, we actually give you back more money you asked us to collect because of the late payment compensation and interest. Because actually it's quite attractive, especially now the interest rates have gone up nicely.
Thank you.
Tabitha.
Thank you, Lucia. There we go. Yeah, Tabitha's got a question as well. So Tabitha, would you like to ask your question? Then we'll move on to Craig.
Yeah, how late does money need to be after end of your terms, sort of 30-day payment terms, for it to be considered, heading over to debt recovery?
Late is late. If you've got 30-day terms, you've got 14-day terms, you've got 7-day terms. Once it's beyond that, it's late. And the Act is quite clear if you're going to look under the late payment. If it's a non-business to business, you probably just add this in, Tabitha, as I'm saying that. If it's a non-business to business, you can use Section 69 of the County Court Act, and that is just a flat 8% rather than the 8% above base that you get with late payment interest. And if you do stuff in the senior court, Section 35A, the Senior Courts Act 1981, but as soon as it's gone beyond your agreed terms, that is considered late, and you can literally, commence it from there.
Thank you.
No problem.
Perfect. And Craig, you had a question as well. So if you'd like to unmute to ask your question.
Yeah, hi there, everyone. It's just a quick one. If we actually wanted to have some terms and conditions actually drawn up, sort of that covers us legally, where can we go? Or is it just a case of making contact with you? Or is there any other places that you could suggest?
You can certainly come to us, and we'll craft you a set of bespoke terms. There are other places on the internet you can find that do terms. You need to be careful, though, of boilerplate terms, because what you'll find is a lot of document precedent sites will say, we'll give you a set, and it doesn't really meet what you're actually doing. And it's a bit like going to show me age, a bit like going down to Burton's to get a suit. You can have a bespoke suit made that actually fits you properly, or you can have one that sort of fits where it touches. Depending on how important it is to you and how important it is to your business. And obviously I'm a little bit biased here, so I'd say it's really very, very important. But of course, I want to make sure that you guys are getting protected. Having the terms that really work for you is imperative, because otherwise, again, if you don't have them, then you can't use them, and then it becomes a much bigger problem. I look at terms like an insurance policy, they're like an investment. You invest some money at the outset, and actually they will last you for years. We have clients come back to us on sort of every 2 to 3 year basis to sort of renew terms, just to make sure that they're actually kept up to date and legal, because stuff does change. I mean, 2018 Data Protection Act changed to the 2018 Data Protection Act. I still see T's and C's now mentioning the earlier data protection. In fact, the 1984 ones I saw the other day, which is absolutely bizarre, because they were in 1998 as well. So it is a bit bizarre that you still see T's and C's dating back to 1984 when I was literally not even in primary school. So show me age.
Okay, that's great. Thank you.
No problem. Thanks, Craig. Very happy to have a conversation offline with you about that.
Real, thank you.
Perfect. So does anyone else have any further questions at all? If not, then we will move on and let everyone get on with the rest of your day. So if you have any more questions, feel free to unmute to ask.
Scared everybody.
No, that's all perfect. So that looks like that is that. So yeah, first of all, thank you everyone for coming along today. This has been our Business Bites webinar. Of course, we do these a couple of times a month. So feel free to join us on our next one, which will take place on the 9th of November. Many thanks again to Martin from Pro Legal Group Limited for hosting this session with us today. So thank you very much, Martin. And to everyone else, I hope you have a great rest of your day. Thank you very much.
Yeah, thanks guys. Have a great day.
Thank you, Martin. Thank you, Henry.
Take care. See you later.
Bye-bye.
Thanks, Sarah. Bye.
Thanks, Martin.
Cheers, guys.